Please the court, counsel, ladies and gentlemen of the jury. 6 shots in the back. No matter how Mr. Collins and Mr. Nolder twist and turn, it is still 6 shots in the back. Now, we talked in voir dire about burden and standard of proof, and the state had the burden to go forward with evidence to prove by a standard of proof beyond a reasonable doubt the charges of murder in count 1, murder in count 2, and reckless homicide. I submit to you, ladies and gentlemen, that we have done that. We have shown that on December 4th, 2020, in Franklin County, Ohio, the defendant purposely caused the death of Casey Goodson Jr. We've also shown that on or about December 4th, 2020, in Franklin County, Ohio, the defendant caused the death of Casey Goodson as a proximate result of knowingly causing serious physical harm. You've heard the instructions of the judge. Knowingly causing serious physical harm is the offense of felonious assault, which is a felony of the 2nd degree. And when that is the proximate cause of death in Ohio, the crime is murder. We have also shown that the defendant recklessly caused the death of Casey Goodson Jr. There is no real argument that exists that the state did not meet its burden and did not reach its standard. Now, we heard time and time again, well, you know, when a police officer shoots at someone, he wants to stop the threat. Stop the threat. That, we heard it, you know, Mr. Collins elicited it from pretty near every police officer that testified. You heard Mr. Davis say, yes, it's to stop the threat, stop the threat. And somehow the implication is that when you point an assault weapon at an individual and you fire it 6 times, either on automatic or semi-automatic, at center mass, the vital organs, that there's no purpose to kill. But you've heard the judge's instructions. Purpose means it's not accidental, it's intentional. You did it on purpose. The instruction tells you that when you use a deadly weapon, and that, ladies and gentlemen, is a deadly weapon, on someone, you may infer purpose. You don't have to, but you may. And I submit when you're 10, 12 feet away from your target, when you've got a sighted in on the vital organs of the center mass, and you discharge that weapon 6 times, 6 bullets, purpose to kill is there. Certainly knowingly causing serious physical harm is there. Knowingly is a slightly lesser standard than purposely. But when you point a gun at somebody and pull the trigger, you are out to cause harm. So if somebody gets up here and tells you, oh no, just wanted to stop the threat, wanted to stop the threat by purposely causing death, by knowingly causing serious physical harm, or the last mental standard, reckless, which is the lowest of the three mental standards, talks about heedless indifference. Point a gun at somebody, heedless indifference, pull the trigger, that's reckless. That's knowingly, and that's purposely. So I submit to you that there is no valid argument on any of the elements that the state has to show to prove the charges that have been lodged against the defendant. I hesitate to say this, but it's almost like it's beyond all doubt. Does anybody have any doubt as to how Casey Goodson died? He died from 6 shots from the defendant that the defendant acknowledges he fired, that even without the defendant's acknowledgement, Caleb Worley come in, he looked at the 6 shell casings that were collected. He looked at the 5 bullets, spent bullets, that were collected either from Casey's body, or that were collected at the site of this, out of the wall of the kitchen, out of the microwave in the kitchen, off the floor of the kitchen, and he compared them, and he told you they were fired from the defendant's weapon. So let's get to what this case is really about. Remember back in voir dire, I talked about the different ways that you defend a criminal case. The Sodi defense, some other dude did it. Doesn't come into play here. There is no question who the participant in this case are. And then the defense of, what is it? Is it a crime? Is it not? Again, the elements are all established, but we have a variation on a what is it, the yes but, the affirmative defense of justification. That's what the defense has raised. And let me remind you, it's their burden to prove that. It's not our burden. It's their burden to prove it. And they've got to prove it to you by what we call a preponderance of the evidence, the greater weight. Put very simply, if you balance all the evidence and it's a tie, they lose. They didn't sustain their burden. They didn't reach the standard that their burden requires. And you have the definition for the justification defense. It's a complex one, and not easily understood, and you know, gives latitude to police officers, which they should have. They're doing a dangerous job. They're in dangerous situations. They should have some latitude. They can be mistaken, and a honest mistake, you know, shouldn't be held against them. But remember, this is not what the defendant thought to establish the justification defense. It is what an objectively reasonable officer standing in the shoes of the defendant would have concluded and what action he would have taken. So just because Mr. Meade says, I had to do this, you don't have to accept that. Not if, looking at all the evidence, it doesn't make sense. Because if you look at all the evidence and it doesn't make sense, then an objectively reasonable officer with proper training would not have fired shots, would not have killed Casey Goodson. Now, the defense brought in an expert to help you. We brought in an expert to help you. You'll have to decide who to believe, because I think you saw very contrasting presentations from the experts. You saw a retired officer, spent 30 years, about half of it training other officers on various things, not just use of force, who said, you know, if you got a hunch, you know, if he could have caused harm, you know, there's the risk. He had to stop the threat. What threat? There was no threat. And then you had Professor Stoughton, who granted what hasn't been a police officer, or I mean, he has been a police officer, but he hasn't been one for 30 or so years, who talked to you about the practices and principles and how they've developed and how they try to train and teach officers and so forth. And freely acknowledged that, yeah, you know, somebody with a gun is a threat. But is he an imminent threat? Is he an immediate threat? Do you take the kind of action that the defendant took? And he walked you through the actions of the defendant that day. You know, he told you about, you know, we train police officers to create time, not to minimize the time. You know, distance is your friend. He's got a long gun. He's got a long gun that he's taking on a handgun. Who's got the advantage? He doesn't have to be 12 feet away from it. He could have been 20 feet away. He could have been 100 feet away. You've been out to the site. You know the distances involved. Elmo, please. Right there. Doesn't need to close the distance any closer than that. He could have been standing behind the tree, position of protection, cover. Doesn't need to be up there at the gate. He could have effectuated everything right from there. but instead he closes the gap. And, you know, we all chuckled yesterday when Professor Stoughton was questioned about the pants on fire fella. You know, yeah, he closed the gap there. Why? Because the man's pants were on fire. Casey's pants weren't on fire. No reason to go any closer than that. So, as you look at the evidence, and as you consider the viewpoints of the experts, who are you going to listen to? Who seemed to be an expert to you? Who educated you about police practices, about how police analyze situations? It was very analytical, very logical, and one that showed you how a well-trained police officer, an objectively reasonable police officer, can do things to protect his safety and minimize the risk to others. We heard the defendant's philosophy. I hunt people. I throw the first punch. Here he fired the first shot. Not only the first, but the second, the third, the fourth, the fifth, and the sixth. 6 shots in the back. I throw the first punch. That's not what they're trained to do. That's not keeping himself safe. That's not keeping others safe. That's murder. You heard Professor Stoughton, and he told you over and over again, despite being asked to resolve factual conflicts, that's not my job here. My job is to come in here and tell you about police practices and how a well-trained, reasonable, objectively reasonable police officer should act. When there are factual conflicts, that's your job. Did you hear that from Kevin Davis? Did you hear him say, oh yeah, you know, there are discrepancies here. I mean, my goodness, you know, the defendant says that he turned and shot him, but all the shots were in the back. Meaning Casey's back is to the weapon when it's fired. Did you hear him say, you know, that's a dilemma here that you, ladies and gentlemen of the jury, will have to resolve? No, he didn't. He said the defendant acted appropriate all the way through. He accepted carte blanches the defendant's explanation. He didn't give you what a objectively reasonable officer would do. He gave you what the defendant did and said, hey, it's all right. He was an advocate. He wasn't an expert. He was in here telling you why, the defendant acted properly. He was advocating. That's not the role of the witness. The role of the witness is to give you information. The advocates are all sitting at the tables here. Take that into account when you evaluate his testimony and you evaluate his conclusions. And you make a determination as to whether he supports, that his testimony supports what they are required to prove. Now let's talk about the evidence. There's a hard and true fact in nearly every criminal case. You have to determine the credibility of the witnesses. Just because somebody got up there, raised their right hand, and promised to tell the truth doesn't mean they did. But let me tell you something. Physical evidence doesn't lie. It doesn't have a credibility test. It is what it is. Physical evidence doesn't lie. People do. And I submit to you that one of the first things that you want to look at in evaluating the credibility of an individual is how it compares to the physical evidence. Because physical evidence doesn't lie. People do. You want to look at motivation. Who on that witness stand had the motivation to be untruthful? You'll have to decide. Was it Sharon Payne? We need to go to the computer. You heard her testimony. You heard the agony of that day. Did she strike you as being deceptive? Did she sound untruthful? Because the other thing you heard was her calling 911. And I want you to listen to it now.
911, what is the address of your emergency?
3996 Estates Place.
And what's the emergency?
My grandson just got shot in the back when he came in the house, and I don't know if he's okay because there's still out there.
I'm sorry, what just happened?
My grandson just got shot.
Okay, where did this happen?
At my house. He lives there with me.
So who shot him?
I don't know. I just
Okay.
heard the gunshots, and I would get up, and he's laying in the door.
Okay. And nobody saw anything prior to this?
No, he went to the dentist or somewhere and came home, and all of a sudden I heard a bunch of gunfire. He's not a bad kid. He doesn't have a police record. He works. I don't know what happened.
Okay, is there anybody in the house that can tell you who shot him?
No, they don't know. They were threatening everybody in the house. I don't know what the fuck's going on.
That's okay. We've got help headed that way. Did they say if anybody was outside arguing with him or anything?
Pardon me?
Is he breathing?
I don't know. They won't let me in the kitchen by him.
Okay. Did he say if he had like any disputes with anybody?
No, not that I know of. I'm not aware of anything.
Okay, what's your name and telephone number, ma'am?
Sharon Payne,
Okay.
614-597-5570.
Do you know if he was dropped off by anyone?
No, he went to the dentist or somewhere. He was driving my car. I don't know what happened.
Okay.
I don't know what's going on.
All right. Well, the officers
There's a
will be
black
that
car
way.
out here waiting.
I'm going to go ahead and get the medics started that way, okay?
That's the damn police. Hold on.
There.
Give
Okay,
me that squad.
ma'am.
That's the police.
Yeah, the police are there, and they've got the medics too, okay?
Why didn't you stop?
Grab a concrete dog, leave everybody out of the house.
Don't have a problem.
Okay, everyone out of the house. Grab the kids.
Inconsistent with her testimony? I don't think so. That's as it was happening. You got the storm door. What do we know about the storm door? Well, there was glass in here that got knocked out from the defendant's shots. Three bullet holes. And the way the bullet or the screen is bent, Amy Culia was able to tell you the trajectory of these three shots. You'll have her diagram back there. We have a nick up here, another bullet. In order for, we know that Casey was inside the door. Defendant told you that. Makes it kind of difficult to turn and face the defendant with a door between them. We know the inside door is open and undamaged. So none of the shots hit it. It was open when the shooting occurred. And guess what's in the inside door's locking mechanism? Casey's keys. He'd unlocked the door. He'd opened the storm door, unlocked the inside door, and had swung it open enough that it was out of the range of the bullets that struck him and passed through him and passed through this door, because all the bullets passed through this door. It's just happened to have this screen to protect, probably because of the big dog. That's the only reason that we have what we have there, because all the glass was, and you'll see it in the pictures, all the glass is on the ground. It's shattered in small granules. I think they make glass that way so that you don't have the sharp pieces that cut people and stuff. Physical evidence doesn't lie, ladies and gentlemen. People do. What else does the physical evidence tell us? We've got Casey's gun. This is the safety on the gun. Safety is off when it's down so that the slide can move. Safety is on when it's up. When crime scene search unit documented the scene, one of the photographs they took, and you'll have it back there, although it's difficult to see on the printed photograph, the gun. Josh, were you there? Where the circle is, that's where the safety is. It's not down, it's up. So what's that tell us? It tells us that Casey had the safety on in his gun. If you're going to shoot someone, you take the safety off. Otherwise, the gun won't shoot. When would you have the safety on? When the gun's in the holster, because you don't want to shoot yourself, and you're not going to shoot it while it's in the holster. And this is the holster, pretty flimsy. So you decide. Did Casey pull the gun out of his holster and turn and point it at the defendant with the safety on? Or perhaps it never left his holster until after he was shot. Remember, there's an extended clip in here. You can't put it because they've made the gun in such a way, thankfully, that it's very safe, can't be fired, but it had an extended clip, which makes an extended loaded clip, which makes the grip part all that much heavier. And you heard from Detective Hughes, I wouldn't have a holster like that. You know, why not? They'll fall out. There's no restraining strap, nothing to hold the gun into the holster other than your body in the holster. So it's not hard to imagine, as Casey fell, the gun falling. And where would you expect the gun to fall? Right where it was found, under his torso, under the right side of his torso, right where it was found after he was rolled over. Physical evidence doesn't lie. People do. We got AirPods, and you'll have the AirPods back in the jury room. Here's where they were documented laying on the floor after the medics had removed Casey. And after the medics, remember Kyle Lighthizer told you, yeah, they were in his ears. As I was assessing him, I'm doing an assessment, I took them out of his ears. This is his dew cap, like a skull cap. What do we know about the AirPods? Well, we know from Casey's phone and Detective Howe that they were connected to his phone. we know from Google records and YouTube music that during the time this all happened, music was playing. And I know the defense is going to say, well, we don't know how loud. We don't know how loud it was playing. You know, and we don't. But we know it was playing. We know they were in his ears. We know that when AirPods are in somebody's ears, and depending on the volume, and I don't have AirPods, you've seen my technological skills. I don't know how to operate them. I don't know how to use them. After I turn the computer on, everything else I have to call my 7-year-old granddaughter and ask her how to do it. But how many times have you had AirPods and didn't hear somebody talking to you? How many times have you had to shake someone who was listening to AirPods because you wanted to get their attention? Physical evidence doesn't lie. People do. We've got a bag of Subway sandwiches. Sorry, I'm just going to switch back on you here. And here's Casey carrying the bag, heading to his car. Just bought them, 3 subs. You'll have the receipt. Here's where they ended up, on the floor of the kitchen, right between the stove and the refrigerator. Not underneath him, because he was carrying them in his hands. Not underneath him. They're off to the side. Physical evidence doesn't lie. People do. So let's imagine, or let's process all the things that were going on at the threshold of Casey's home when he returned that morning with the sub sandwiches. He's got the subs in one hand. He's got a pretty bulky set of keys, and you'll see that. Didn't pull the picture, but you'll see the keys hanging in the door. We know he's got the Subway sandwiches because we see him there at Subway shop, and we see him on the kitchen floor. The only way they get there is somebody transports them, and Casey's the only one to transport. We know he had the keys because the keys are there to unlock the car, unlock the door. And on that set of keys is the car key. It's right above the little Mickey Mouse statuette. So he had to transport the car keys that have the house key from the car to the back door. So, one hand, Subway sandwiches. Other hand, keys. I submit they're probably in his right hand because He's right-hand dominated, but more importantly, the lock and the door, the handle to the door are on his right side. Gun. Well, we know he's got the gun. It's out of hands. Where's the gun? The gun's in the holster, in his waistband. Kyle Lighthizer told you, I saw a holster in his waistband. Officer Rosser told me, I saw a holster in his waistband. Subway sandwiches, keys, gun. What's he turning point with? The Subway sandwiches? 6 shots to the back. Not the front, not the side, but the back. His back is to the shooter. Professor Stoughton told you, yeah, of course somebody with a gun is a potential threat. A potential threat. But we don't have our police officers acting on potential threats. What happens when they act on potential threats? Exactly what happened here. And that's not justification. That is not justification. Now let's talk about the shots themselves. This, I guess we need the bottom here. This is the diagram that Dr. Shepler prepared based on her findings in her autopsy. And it's showing the upward trajectory of each of the bullets, because they all were going upward. None of them were going down. We got the 3 in the upper back. Now, we're gonna hear, well, wait a minute. That's all based upon standing up straight. Well, yeah, they've got to have some metric to measure off of, and to set it forth. And people aren't necessarily standing up straight. They move, they twist, and so forth. But what can we tell from this? I submit to you, ladies and gentlemen, that the first thing that stands out is that the 3 shots in the upper back, the ones that did the most damage, were the first shots. Because though Casey may not have been standing straight upright like this in the diagram, he was more or less in that position. And they all have very similar upward trajectories. But let's look at the lower shots. And what does that tell you? Well, you know, your body has a pivot point right around the waist. And so as you bend, shot that would normally pass through you at the upward angle that you see in the upper shots gets a sharper angle because it's coming in as you are bending. If it's below the pivot point, you have a bit less of an angle. But here, we have a sharp angle that's right above the pivot point. We have the shot in the buttocks that it has a lesser angle. And then we have the gash in the side that has a sharp angle. Consistent with falling. Consistent with falling. And if the first 3 shots are the upper back, what are they going to cause? Falling. So I'm sure we're going to get some demonstration again of twisting and turning and getting the ruler out and so forth. But what makes sense here? What makes sense? Now let's talk about the timing. Because if, as the defendant claims, Casey has turned his body to point the gun, he has to have turned it all the way back, pretty much square to the shooter, before any bullet strikes him. Does that strike you as reasonable? Did they establish that to you by a greater weight of the evidence? By a preponderance? I mean, there are quick people out there. There are people that are very fast, but that's like lightning fast. 6 shots to the back. The bottom line, ladies and gentlemen, the physical evidence just doesn't line up for them. It contradicts everything that the defendant claims happened in that doorway. It just doesn't make sense. Play the lights video. Remember what the defendant told you after the shooting, the priorities were? Make the house safe. Make the house safe. And by the way, he supposedly first is inquiring, why is a man coming into your house with a gun? Did you hear that from Ernest Payne? No. Ernest Payne said they pointed a gun at me. I'm holding my 3-year-old daughter, and they said, get on the floor. Did you hear that from Sharon Payne? No. Ernest told you because Sharon was obviously tunnel vision. You know, Ernest said she was right next to the guy, to the marshal with a gun, and he's telling her, get back. You know, and she's not paying any attention. But it's not, why is somebody coming into your house with a gun? You heard at the end of the 911 tape. You hear the marshals. And did they seem concerned about who is this guy that came into your house with a gun? No, they're herding them out. They're pushing them out of their home. Sharon Payne told you she went to or headed to her closet to get a coat. It's December. You know, she's got small children, to get coats for them. They wouldn't even allow that. Get out of the house. Get out of the house. We got to make it clear. And the defense says, yes, that's the priority. We got to make it clear. We got to clear the house. Well, let's see how much of a priority it was for you. We need the computer again, please. Okay, stop. This is Officer Sam Rippey's body cam. You'll have the whole body cam back there, but Officer Rippey is one of the first officers to arrive there, and he's moving forward with his gun drawn. He doesn't know what's going on, because guess what? One of the practices and principles of policing, communicate. It wasn't happening. It didn't happen. I guess clearing the front yard was important. I mean, that's the defendant. And they haven't cleared the house yet. Okay, go ahead. Let's see what he does.
Okay. We got a medic on scene, but they're...
Yeah, I know. That's what I said. Don't send them in yet.
Okay.
So the medics are there. Help is there for Casey. And what does the defendant say? Hold the medics, because the house isn't clear. Okay, go ahead.
Tell them to stay. Tell them to stay. Come out this way, folks. Come on.
He'll keep getting to sleep. But do you notice the change in the taillights? Back it up and play it again. The defendant's getting into his truck.
Come out this way, folks. Come out. Hey, come out this way. We'll send them.
Now that sure was a priority, wasn't it? Better get my lights on. House isn't cleared. I just shot a guy 6 times. He's lying on the floor, dying. And the defendant's out turning on his lights. How's that a priority? Mr. Schroyer asked him about it. Oh, I don't remember doing that. He had 0 explanation for it. Physical evidence doesn't lie. People do. Where else has the defendant lied? I just strike that. I'm not going to call him a liar. Where else has the defendant been deceitful? Well, we've seen over and over again the intersection at Ferris and Carl. I think it's important that you remember that the defendant provided a statement to investigators. And in that statement, he said, or wrote, as I was sitting at the light at Ferris and Carl, I see this car approaching southbound. He stops because there's northbound traffic coming through. And as he stopped at the intersection, I see him waving a gun. And as he stopped at the intersection, I see him pointing the gun at the car proceeding through the intersection, the northbound car, tracking the driver. And that alarmed me. And then, once the northbound driver cleared the intersection, he then turned left in front of me. And as he came by me, he pointed the gun at me. Then he drove on. That's what he told investigators through his written statement. You've watched that Ferris and Carl intersection video time and time again throughout this trial. Casey never stopped. It was a continual left turn. What's the defendant's explanation? Oh, well, I was wrong. I guess he didn't stop now that he's confronted with the physical evidence that doesn't lie. He's got to back off. But I still saw everything that I saw. In fact, as he went by me, I ducked and I reached for my gun. Okay, there's the left hand. And I'm narrating on the radio, handheld. There's the right hand. What's he driving with? What's he turn around with? But that's not all that exists in this case to show you the fabrication at that intersection. You heard yesterday from Christopher Korn. And Christopher Korn, as we all now know, by happenstance, was in the van immediately behind the defendant. And what did Christopher Korn tell you he saw? That I saw this young man dancing in his car, consistent with what we know, AirPods, playing music. And he said he even looked like he was singing. You wouldn't want to hear me sing. But time and time again, when I'm in the car by myself, I'll sing along with the, don't have AirPods, along with the radio. And I'm good then. What's that consistent with? It's consistent with the YouTube music. It's consistent with the AirPods. Now, they're going to get up here and they're going to tell you all the reason not to believe Christopher Korn. Because, you know, frankly, they know that if you believe Christopher Korn, then the case is over for them. Because he exposes the cover-up. And it began with when he turned his lights on while Casey was dying on the floor, and continued when he submitted his statement with this supposed pointing of the gun. Because if Casey didn't point the gun at him, where is the risk? Where is the need to the urgency to do anything? If he'd been or followed his training or been properly trained, there wasn't a need. He would have wanted to build time, as Professor Stoughton told you. Create time, create distance. But boy, take out pointing the gun at the intersection and everything collapses. So what about Mr. Korn's testimony is unreasonable? Well, I think the fact that it came at the last minute, that he didn't make himself known to law enforcement, that's something you can consider. But you've watched this, or you've been here every minute, and every minute you've been here, that camera's been here. They aren't just taking home movies. They're broadcasting it everywhere. And back when this happened, there was all kinds of coverage in the media. So is it that astonishing that this guy says, you know, I really didn't want to get involved. Once he realized that there was something there, that he had seen something of importance, because initially he didn't know. He turned around and followed the defendant and Rosser because he's a little ghoulish, I guess. You know, you think, oh, they must be going to do something. Maybe I can be a little entertained. Maybe I can see somebody's door get kicked in or something like that. You might not choose to do that, but you know, there are people that chase fire engines. There are people that have police scanners, and they're listening all the time to the activity because they find it interesting. But once he figured out that, oh my goodness, I was right in the middle of this. Is it astonishing that he didn't want to be part of it? But yet, he also recognized that he did have an important piece of information. So, when asked, why did you come forward? He said, I just had to do the right thing. I had to do the right thing. And it was the right thing. He wasn't obligated to come forward. He did nothing wrong. You witness a bank robbery and watch the robbers jump in the getaway car and drive away. You're not obligated to follow them. You're not obligated to stand around there and wait until the police came and say, hey, I saw the robbers go that way. You're not obligated. We hope citizens will inform the police of of information. It's helpful, absolutely. But it's not an obligation, despite what Mr. Nolder would make it sound like. Now, Mr. Nolder's a very skilled lawyer, and I think if you watched the cross-examination, you saw a skilled lawyer at work, because Mr. Nolder said, well, you wanted to do the right thing. Was it the right thing to take down your Facebook? And Mr. Korn said, well, I suppose not. Nothing wrong with him taking down his Facebook. I'm a technological caveman. I'm not on social media. I don't know any of that stuff. Got to call my 7-year-old granddaughter to find out. But it makes perfect sense to me that once media got a hold of his name and broadcasted it throughout the whole area and so forth, and he opens up his Facebook, and here are 100 or more friend requests from people he has no idea who they are, that he's think, man, you know, the easiest way to stop this is to take down my Facebook. So was it the right thing to do? Depends on your perspective. Was it the wrong thing to do? No. There's no obligation. Mr. Nolder made it sound like it was an obligation. Mr. Nolder made it sound like he was doing something wrong. He did nothing wrong. He took his Facebook down. He had made a number of posts, apparently, and I had to call my 7-year-old granddaughter to find out what all that meant. But I guess on the news or on the internet, you have the ability to post, write a comment or put a thumbs up or, something like that. And he did that. And then he took them down. Because shockingly, as he was progressing through this as to whether to come forward or not, he began to have second thoughts. Mr. Nolder made it sound like, oh, wow, that wasn't the right thing to do, was it? No, I guess it wasn't. But it wasn't the wrong thing either. It was a reasonable thing to do, given the situation. Does it mean he didn't see what he saw? Does it mean that he came in here and fabricated all that? Who's got the motive to do that? You got contrasting stories. One person says he's got a gun in his hand. The other says, I saw no gun. I saw nothing in his hands. My attention was drawn to him because he was dancing in the car and he was somewhat erratic. I thought at one moment that he was going to hit me. That's what was notable to me. Who's got the motivation to do this?
Councilwoman approach.
switch us over to the computer, please? Much to your relief, I'm almost done. There's a lot more I could say. Remember, back in voir dire, we talked about why did this happen? Why? And I said, you know, you may end up at the end of the case still asking that question, and it may still be unanswered for you, because that's not part of our obligation. We don't have to prove motive. But ladies and gentlemen, the defendant told us why this happened. I want to play it for you now.
He came out the street, gun in his hand, going to the side door, going in with a gun.
As you guys were pulling out?
Yes, as I was pulling up.
Yeah, Joey asked for us to go.
Doing this. Who's in charge here? I was one that was on the scene. I was one that was initiated.
Does that sound like someone who, like a objective, reasonable officer? No. He's going in the house with a gun. I had to stop him. There was nothing that he had done that indicated that he needed to be stopped. Especially when you eliminate his manufactured reason initially to be looking at it. No one saw a gun except the defendant until it was on the floor at 3996 Estates Place. No one, not Officer Rosser, no one. Why didn't they? Because it was in his holster. Ladies and gentlemen, consider all the evidence, evaluate it, and return a just verdict for Casey, who did nothing wrong, but had the terrible misfortune of crossing the path of Michael Jason Meade, an aggressive, arrogant, and remorseless officer who sat before you and told you what disturbed him wasn't taking an innocent life, but that he ruined his son's birthday.